I call the Honourable David Parker.
At the risk of banging on about it, to use my colleague Charles Chevelle's words, I am actually going to return to the issue of the Serious Fraud Office. It's a serious issue, and it comes up again in relation to Clause 106 of the bill, because Clause 106 of the bill sets out the people who the Attorney-General may authorise to issue warrants. And it sets out various protections that were either in the bill or were added by the Select Committee. The Select Committee said that there were some provisions that needed to be added to the rules relating to who could issue a warrant, who could authorise the issue of a warrant to an enforcement officer. Now, warrants are necessary for most search and surveillance procedures by the police. In fact, all search and surveillance procedures that are trespassery, unless they're in an urgent situation during the commission of a crime, effectively you need prior authorisation from a justice of the peace or a judge, a community registrar, deputy registrar. This is Clause 106. Now, we at Select Committee were advised or heard submissions and thought that this needed tightening because the words "or other person" meant that the class of persons who could authorise the issue of a warrant was too broad. And we tightened that up by making it clear at 106(1)(a) that the Attorney-General may not authorise an enforcement officer to act as an issuing officer. So a policeman can't authorise the issue of a warrant to another policeman. Further, we added 106(a) to say that an issuing officer who is employed or engaged by a law enforcement agency must not consider or perform any function in relation to any application made by a law enforcement officer employed or engaged by the same law enforcement agency as the issuing officer. So that's to get around the situation where someone might be a justice of the peace working for the Fisheries Department, for example, and they ought not to be able to authorise the issue of a warrant to the Fisheries Department, because clearly a JP could be in quite a junior role in the Fisheries Department could come under the influence of a more senior person in that same organisation. And again, the government have agreed that's an appropriate limitation on who can issue warrants. Contrast that with the position of the Serious Fraud Office. The Serious Fraud Office, they are their enforcer. They don't have to go to someone who is not an enforcement officer to exercise their powers. They do it from an internal administrative act. So again, Minister, I ask you to justify why 106 is proper in respect of all of the enforcement agencies in New Zealand. All of the arms of the Crown except two will be covered by this. One exception is the Security Intelligence Service. They have separate legislation, and their actions, if they're going to exercise search and surveillance operations, they have to get that approved by the Commissioner of Security Warrants. Charles Chevelle tells me, I've forgotten the exact term myself, who is generally a retired High Court judge. So they have a specialist High Court judge who oversees the issue of warrants to the Security Intelligence Service. And the other exception is the Serious Fraud Office, and they don't have to go to anyone. They do it internally. So, Minister, where is the principle that underlines what I think is the stubborn refusal of the government to bring the Serious Fraud Office into line with the processes that have to be followed by every other state agency before they exercise some of these intrusive powers? Mr. Chairman, can I also turn to how this links into the recognition of privilege? Because the recognition of privilege that is provided for in subpart 4 of this part of the bill, at clauses 130 on, lists the sorts of privileges that people can claim. Legal professional privilege, privilege with legal advisors, privilege for the preparation of materials for proceedings, privilege for settlement negotiations or mediation, privilege for communications with ministers of religion, privilege for information obtained by medical practitioners and in clinical psych. Mr. Chairman.
I call the Honourable David Parker.
Privilege, thank you, Mr. Chairman. Privilege for against self-incrimination, privilege for informers, and rights conferred on journalists under Section 68 of the Evidence Act. Now, those are the different classes of people who can sometimes claim privilege. Can this privilege ever exist to protect those groups of people in the public interest? Because behind those privilege lies a public interest in non-disclosure, which outweighs the public interest in the police being able to get the information. Can those sorts of claims of privilege ever be made in respect of the Serious Fraud Office? No, because the Serious Fraud Office provisions are not subject to this part of the Act. Mr. Speaker, I want to make it clear that if there's a dishonest purpose, there are journalists, and you see it, in those famed cases over in America where you have crooked lawyers or crooked journalists who are part of some mafia conspiracy. Well, those sorts of cases where the journalist or the lawyer is actually part of the dishonest purpose are expressly excluded from privilege. So we're not protecting bad people here, we're actually just protecting the public interest in the privilege that traditionally or has grown at common law to protect and recognised in statute to protect certain sorts of information and relationships where there is a public interest in those communications being kept private that outweighs the public interest in the police being able to get at that information. So, Mr. Chairman, I invite the Minister to say what's the difference for the Serious Fraud Office.
I call the Honourable Minister Judith Collins.
Mr. Chair, thank you very much for the opportunity to speak on this bill at the committee stages. First, I would like to thank